Welcome to the Digital Healthcare Experience, brought to you by Taylor Healthcare. Welcome to the Digital Healthcare Experience. I'm Naomi Schwimmer with Taylor Healthcare. Thank you so much for joining today. So we're here today with a great panel to discuss informed consent and the role it plays in both legal protection and patient satisfaction. And actually, the topic for today's event was inspired by an article that was written by one of our panelists, Solveig Dittmann. And so for introductions, we'll start with her. Solveig Dittmann is a manager of risk management and analytics at Coverys Medical Liability Insurance and Solutions, and she most recently served as senior risk specialist. She currently serves clients and leads a team of risk consultants based in the Midwest region. Solveig is a registered nurse with over 30 years of healthcare experience, and over 10 of those years have been focused on risk management, patient safety, accreditation, and quality improvement. We also have Chad Brouillard, Esquire, a medical malpractice defense trial attorney and healthcare lawyer. He is a partner at the law firm of Foster and Eldridge in Massachusetts. Chad has written extensively and speaks internationally on the topic of information technology liability, and he's also a course creator and adjunct professor at Tufts University School of Medicine Public Health Division, where he teaches information governance in healthcare. Chad is licensed in New Hampshire, New York, Massachusetts, and the federal courts, including the Supreme Court of the United States. So a quick note, if you enjoy this panel and you're attending HIMSS, or if someone at your organization is attending HIMSS, Chad will also be speaking at HIMSS on the topic of informed consent in the context of AI and the evolution of patient-centered care. So if you know anyone at your organization who may want to see this talk, we'll be sure to send you the link to register for that event afterwards as well. So now on to our moderator, Doug Stefano, and I'm going to switch our view to the speaker view from here on out. Thank you, everyone, and thank you, Doug.
Thanks, Naomi. Hello, everybody. Good afternoon, and welcome to our third installment, kind of centered around informed consent, and I'm going to jump right into it. So let's get started with this question is going to go to both of you, Solveig and Chad. How do you define an effective informed consent process? And let's start with you, Chad, if you want to go first, please.
Thank you, Doug, and thank you, Naomi, for the introduction. It's good to be here. So very interesting topic, and I'm very interested to hear what Solveig has to say about it, too. When I think of what's an effective informed consent process, I'm really applying my lens as a trial lawyer. You know, what is effective to me means, is it something that is in place? It's a process that's vetted, that's going to, provide adequate legal evidence that in fact an informed consent discussion took place, and is it going to be defensible later? But I obviously recognize that our requirements in the law are also based on patient needs, and one of the things that I really enjoy about having talked about this topic is informed consent is really something that goes back over a century, because there were always complaints about, did a physician go too far? Did he or she perform the proper surgery? Or did the patient really, consent to what was happening? And really, these cases were tried under a theory of battery, of an intentional touching of another without consent. So it's a really fascinating topic. And to me, one of the most interesting portions in that history was a patient who was under anesthesia, and a surgeon basically was doing an exploratory surgery and found that there was a GI tumor and just removed it. Didn't bother to wake the patient up, just went ahead and performed surgery on the patient beyond the scope of what was agreed to. And that's really one of our basics in terms of informed consent and the legal definitions that surround informed consent. So to me, the contour of a good process is one that essentially is going to be legally defensible, where it kind of balances the rights of the patient to be fully informed about what is going to happen to them, and and being apprised of the risks, the benefits, and alternatives. And on the other hand, being balanced against the rights of the surgeon or the clinician, and making sure that you have something documented and in place that shows that this back and forth conversation, in fact, took place and consent was obtained. So, from my view, that's what I look at in terms of what would be an effective process. It's one that's the most legally defensible, that's very specific to the procedures being involved, and clearly has the consent of the patient to proceed.
Awesome. Thank you. Solveig, how about your stance on it?
My stance comes from a clinician standpoint, having been a nurse for actually over 45 years. I think that informed consent, a good informed consent process is a process in keeping with shared decision making between the patient and the physician. And that's a process in which patients are fully engaged with their provider, who gives them all the information that the patient needs to make decisions about their treatment in terms that they can understand. And that's a big part of it as well.
Awesome. Thank you so much. In the context of malpractice lawsuits, and I'm kind of in your sweet spot here, Chad, how crucial is a well-documented informed consent process?
Yes, and Doug, I like the way that you're giving this question, because you're talking about an informed consent process. And very often what I run into with clients is confusion, because they have the hospital informed consent form, which is boilerplate, which is signed by the patient, and they think, well, of course I obtained informed consent. Look at what's been filed. But very often when we get into the details about what was actually on that form, did it actually list the procedure in question? Did it actually cover known risks of this exact procedure, not just the general surgical risks? Does it have a discussion about potential alternatives, or was there a documented discussion about potential alternatives? All of which is required by the law, right? So, I think it's a type of topic where it's very easy for clinicians to get confused, because they think it's just a simple form, and it's not. It's just as Solveig said, it's a shared decision-making process, right? And so the more that you have robust documentation that can demonstrate that an actual conversation took place, so in other words, the patient didn't just receive this form and sign it, halfway through being sedated, right? As they're being wheeled in. Was there actually a fulsome discussion that took place, and what were the contours of that discussion?
All right. So now you just kind of led me into having to ask this question, right? So do you have any evidence or any cases that you've been involved in where insufficient documentation has, led to some legal challenges for a provider?
Oh, yeah. I mean, I would say in the majority of my cases, I think that plaintiffs' counsel are always assessing, is there an informed consent argument to be made here? Because that's the duty to their client, to see if any applicable legal theories are going to apply. Not just negligence, not just did the doctor do something correctly or incorrectly, but also did this informed consent process take place? So, very often for the clinicians who really look at informed consent as just that hospital generic form that gets signed, it can be very problematic, because those forms don't reflect a specific procedure which was being contemplated. And so if you have a very specific risk to a type of procedure occur, the patient is always going to say, oh yeah, I had a discussion about this form. I didn't read it. I just trusted the doctor. Doctor never said this very specific risk could happen to me. And look, it happened to me. So there are always challenges, I think, in medical liability cases when you don't have very specific documentation, either in the progress notes or the consent form itself is too generic that it's somewhat of a mismatch. And there are plenty of cases that have been reported that are exactly along those lines.
Crazy. So Solveig, based on your experience and the data from Coverys, what trends have you observed in the informed consent claims world that exist out there?
Well, it's not necessarily trends in certain types of procedures. It's more trends in the type of circumstances around the procedure. Give you some examples, such as when a provider fails to delineate more conservative ways that they could treat a condition, such as medication versus surgery, and an adverse outcome occurs. One situation I was aware of is the patient saw a bariatric surgeon because it was interested in weight loss, grossly obese patient, and the physician failed to mention that there are now medications out there that have prescription medications that have been useful in providing weight loss, and just went right to having the patient sign a consent for a gastric sleeve surgery. And the patient did have an adverse event which caused the patient to spend quite a significant additional period of time in the hospital. And when she realized that she talked to a friend who had had some success with medications, and the physician failed to offer her that option, she was very disappointed and filed a claim. Another example would be, as Chad mentioned, the failure to fully describe the risks of a procedure. For instance, if you have a cholecystectomy, perhaps by either laparoscopic surgery or open surgery, and there's always a possibility of perforation. And I was familiar with a case where there was a significant bowel perforation during a cholecystectomy, and that was not listed as one of the possible outcomes of that surgery. So that was also an issue. And then it's not only procedural, something I'm very familiar with, having worked in the psychiatric arena for a number of years, is failure to provide informed consent for psychiatric medications. It's not required in all states, but many states require it, but that doesn't mean it isn't the right thing to do from a defensive perspective. There are many psychiatric medications that can cause significant side effects, some of them permanent, such as tardive dyskinesia. And if an informed consent is not obtained, where a patient with a psychiatric condition was not told that they might develop permanent mouth movements and tics from a medication, I've seen many cases where that has been sent to a claim. And then I think that's typically, it's really that circumstance when a patient is either not offered a less significant treatment, and something happens with the one that they have. Oh, I just thought of another one. A patient had a breast cancer, and similar to one that her sister had, and her sister was offered a lumpectomy with radiation. And this patient went to her oncologist, and the oncologist said simply, well, we do have to do a mastectomy. And after she had the mastectomy, she talked to her sister and she said, wow, I'm just really concerned about this. And she got a second opinion. She got her medical records, got a second opinion from another oncologist who said definitely a lumpectomy and radiation would have been an option here. And she was not even offered that as an option.
Yeah,
Doug, can I just add one thing
sure.
to what Solveig said? Because when you were talking about this, it just reminded me of like one particular gotcha, I think, in the consent space is not telling the patient what might happen if they do nothing.
Exactly.
Right.
And that's always an option. We wait
Mhm.
and see. We do, we don't move forward with the procedure just yet. I think a lot of providers don't think about that as being in the risk, alternative discussion.
Yeah. Wow. So I heard a lot of really good input from both of you so far. One of the things that's been kind of permeated through both of you is it's not a one-time event, obviously, right? Like we're not just consenting as a one-time thing and then it's over with. It sounds like it's really a process. It's a process that has to continue both from a healthcare system, a hospital, from a provider, even from the clinician standpoint, right? That's the big thing I'm hearing. And so, Chad, interesting, like do you, how can healthcare organizations more effectively educate, right, their employees, their physicians, on this process and make it this a continuous process versus a one-time event?
Yeah, I mean, I would think that, you essentially, if you have an organization, I do think that providers probably need some additional training on what is the full scope of informed consent. Um, but I honestly, my anecdotes are I see kind of what some healthcare providers are doing. Um, and the really good informed consent processes I've seen have a couple of earmarks, and one of them are forms that are very specific. So if you have a practice, say you have a GYN practice and they're doing hysterectomies routinely, and so they develop um, a custom consent that really addresses all of the pertinent things for that procedure. Um, the other thing I really like with consent processes are organizations that spread it out over time, right? So that there's one note which says, hey, we're talking about alternatives about the scenario. We're going to talk next time about our recommendation for the procedure. There's a follow-up note. There's a note from the day before with someone else talking about risks and benefits of the procedure. Obviously, the more evidence about specific conversations and fulsome conversations with the patient are great. And the other thing that I really like to see on defending these claims are when there are multimedia, so that the patient is given a website, the patient is given a video, the patient is given, supplemental materials, graphics, things along those nature. Anything that can show a really concerted effort to educate the patient, I think are great tools when I see them in place.
Right. So I mean, it's
can
almost
add
like the teach back mentality. Go ahead, Solveig. I'm sorry.
I can add something to that too. I think in terms of educating providers, coming from the perspective of a risk consultant who goes into facilities and reviews different processes. One of the things I highly recommend is that for someone from in the risk management or quality arena to periodically review informed consent documentation. So not only, the signing of the consent form,
Right.
but reviewing records for that documentation by the provider of that consent discussion. And I think that's critical. It often involves reviewing records not only in the facility where the procedure occurred, but also in the clinic where the informed consent discussion may have taken place with the surgeon and the patient. So, and then doing the just-in-time education to those providers when it's obviously lacking. And then
Solveig.
also
Go
to
ahead.
emphasize, it is a non-delegable thing. You cannot,
Awesome.
the physician, the person who's performing this procedure must do the informed consent. And that includes anesthesia consent. So you've got not only, say, surgical consent, but you've got anesthesia consent. Both the anesthesia provider and the surgical provider need to have those discussions. And I have been in facilities where a nurse has got the informed consent on a clipboard and they go over to the patient. Did the doctor talk to you about this? Okay, then you can sign this. That is not appropriate. So.
Awesome. Let me just tag on real quick. So one of the things, Solveig, you probably, I'm sure, does this impact or do like regulatory agencies like DNV and Joint Commission, are they looking at the informed consent process and what that
Absolutely.
looks like? Oh, it
Absolutely.
is. And
Oh, yes. Yeah,
it's
they
something that
definitely.
okay.
Yeah, they will definitely look for not only the signed consent, the dated, timed, and signed consent, and the contents of the informed consent, but they will look for documentation in the medical record by the provider about that discussion. And so will
Awesome.
CMS. If CMS comes in, they will look for the same. They will certainly look for the components that they want in a conformed consent, informed consent, which include those risks, benefits, and alternatives.
Yeah, and also I just
Awesome.
add in some states, so for instance, in Massachusetts, we have a board of medicine which has made its own rules about what informed consent is. And
Yeah.
so you sometimes have boards of medicine looking into this issue when there are patient complaints. Did this comply with our board rules about what belongs in the informed consent process?
We also in Minnesota have one that comes from, excuse me, the Minnesota Alliance for Patient Safety. And the Minnesota Hospital Association has highly recommended that every facility in Minnesota use that form.
Okay, great. Good to know. I think, Chad, in Massachusetts, right, one of the newer laws was every physician and clinician that's in a procedure has to be signed, right? They have to actually sign the document
Well, they
or
have
at
to at
least
least be
They have
they
to
have to
be
be documented,
named. They
identified.
have to be
named.
named.
Yeah,
Mhm.
Yeah.
yeah. Interesting. Okay, awesome. So let's get to Solveig. Solveig, you highlighted the importance of like open-ended questions during the informed consent discussion. Can you share any successful strategies that have been, proven to enhance patient engagement and patient understanding?
Absolutely. After we recommend, and I always recommend when I go into facilities, that after the consent is obtained, you ask the patient to describe in their own words what's going to happen. And I even have seen organizations that not only have the patient describe in their own words what will happen, but actually write on the form, I am going to have the following procedure and I consent to this. This is what I am going to have. And then also open-ended questions would be not to use the strategy at the end of the discussion where you say, do you have any questions? Because typically a patient who's nervous anyway is just going to say no.
Right.
Better strategy would be to say something like, this is a lot of information I've given you to absorb. What questions do you have for me? It's much more open. It's inviting those questions. It's saying, I understand. By saying it's a lot of information, it's saying, I understand this is a lot of information. So it's giving them more permission to ask those questions. And I want to make a comment to a little illustration of how important it is to explain the procedure in words the patients understand and get that clarification back from them, the teach back. When I was a very young nurse, I took care of a patient post-operatively that had had a cholecystectomy, an older fellow. And when he came up to the room, I was checking his dressing, and he looked up at me and he said, does this mean I'm going to need to wear a bag for the rest of my life? And I said, excuse me? He says, for my colon. And I said, oh, no, you didn't have a colostomy. You had your gallbladder removed. And in this case, obviously, he wasn't going to sue because, he didn't
Yeah.
understand the consent because he was thrilled that he didn't have a colostomy. But this
Yeah.
does illustrate a colostomy, a colonoscopy, a cholecystectomy. All the words are very foreign to the lay
Yeah.
population. And so, in this circumstance, it was good, but you can only imagine if somebody didn't really understand what they were going to have and the outcome was bad.
Yeah. And I think that right now we're going from sixth grade reading level down to fourth, I think is
Fourth
the
grade.
goal.
Fourth grade.
Leapfrog, right? Yeah.
Yeah.
So it's
Plain
getting even
language.
tougher.
Mhm.
Yes.
And interpreters if necessary.
Right.
And hopefully not a family interpreter.
No.
Somebody who will clearly explain and not slant what the physician is telling them.
Exactly. Okay. Now, Chad, this is the money question for you because all we hear about is AI. It's going to save the world. We're not even going to need doctors anymore. It's just going to be robots doing procedures. But as AI becomes more prevalent, right, in this healthcare decision process, how do we foresee like the legal side of this evolving, right, with in consents and things like that?
Yeah, I mean, I think that AI's real potential impact in the informed consent space is I think you could see ways that it could be used to bolster an informed consent process. One might be we're talking about making sure that forms are very specific and we're making sure that the specific risks are being brought to the patient's attention. I think AI, the current generation of tools that we're looking at, does a very good job at getting very specific, and providing sort of boilerplate responses to very specific concerns, or maybe boilerplate's the wrong word, but consistent responses to very specific concerns about things like, what are the risks of this potential surgery? So as a learning tool, do I think it could be very helpful? Absolutely. The other thing is you may not have seen this article, but essentially USC San Diego, I think their medical center decided a pilot where they switched out the patient portal with actual live clinicians with ChatGPT, and they wanted to see what patients thought. And the patients overwhelmingly preferred ChatGPT over real clinicians because they felt they were, you have to look at it from the clinician's point of view, right? Where they're in an industry where they get 15 minutes with a patient, they're rushing from appointment to appointment,
Right.
so they get these patient portal queries, and it's the last thing they need in their clinical day, unfortunately, and they don't have the time to give it fulsome, empathetic responses. Unfortunately, they're just very tapped for time. ChatGPT in this study, of course, has all the time in the world, right? It can seconds generate responses to patient queries. So you could imagine what I'm talking about, what I really like when I see a physician's practice office that, they try a whole multimedia approach about education, right? They're using illustrations and animations and external reading. You could see the use of a chatbot, in an educational platform to, kind of help respond in a very empathetic and very sort of learning oriented way. So, but I hear what Solveig said sort of at the end of her last topic, which is being very careful that really what we're talking about is that the consent process at some level has to be non-delegable to the actual physician who's performing, right? Well, I that's the rule in my state. So, that absolutely is a legal requirement. But I think when you're talking about supplemental education and supplemental information, you can have a nurse providing more information as long as the provider did what they were supposed to do and felt they gave all the good information when they were obtaining consent. But it doesn't preclude other members of the healthcare force or AI from reinforcing those messages. Or, like for instance, I encountered a practice who their practice was at least a couple weeks before surgery, the informed consent process between the primary operator and the patient has to take place, and it's very well documented. But they also schedule follow-up calls with nursing staff who had general information and, basically checking in with the patient and said, okay, you consented to this procedure. Let's review some things. Do you have any questions? Kind of what Solveig was getting at about making it less threatening and more open-ended. Some patients, for instance, might open up more to a nurse than they might a surgeon, So I don't think it's a bad thing to supplement the formal obtaining of consent with further educational tools or discussions, including with chatbots. I mean, I think that's all in the realm of possibility. I'm sorry that was so long-winded, but those are my
No,
thoughts.
it's awesome. Well, I mean, I think everybody wants to know, right? Like, I mean, again, I think you told a great story once about a dinner reservation you made, and it was AI, and you got to the restaurant, and they started quizzing you, and you're like, I talked to a person, and they were like, no, you talked to our chat bot, and so it's coming, right? It's here. It's pretty impressive. I mean, you can go into ChatGPT tomorrow and type in anything you want about a procedure and get a great, like you said, answer. I guess what maybe the next phase of this is, it sounds like a good process has to exist. The conversation still has to happen from the physician and the patient, right? AI is a great bolt-on, added, better, making your process even better. But there's still that. How does a hospital now navigate the legal landscape of that, right? God forbid if something goes awry.
Mm-hmm. Yeah, and I think that's a moving target, because part of the discussion would be, well, did the AI software itself, was its data set skewed? Were the data sets biased and it provided an inadequate answer to the patient, or was there, with the modeling, was there a defect? That might be very difficult for a hospital system to answer. Um, and legally, there's suggestion that maybe the software vendor has some skin in the game, potential liability,
Right.
versus the flesh and blood providers. But there's so many unknowns that it's a legal gray area that will likely keep me employed well past my children going to college. So I'm very grateful for that,
There
at
you
least.
go. Exactly. I need that. I need the job that gives me employed. I got three girls. They're killing me with this college tuition. But let's talk about liability, accountability, even like negligence in cases where AI systems, contribute to an adverse outcome, or where an informed consent may not be explicitly covered by AI related risk. What do you think about that?
Oh, absolutely. There's a space for that. So we actually have an early AI case that goes back to 2012 that was more in diagnostics than informed consent. But
Okay.
in essence, the algorithm missed a key differential, or key element of the differential, and it's what the patient actually had. So the physician who used the tool was in a position of saying, "But I checked the software program, and it didn't give me the diagnosis that you're suggesting should have been on the differential." And so the plaintiff's attorney actually added in the diagnostic company with the algorithm. And under the theory, they sort of push back, and legally, products manufacturers are protected from being brought into medical liability suits because they say, well, wait a minute, you'd have to prosecute this under a products liability theory of the case, which is highly technical. But in this particular case, the court said, no, as long as you have a standard of care expert who says this should have been in the differential, we don't care who generated the information, whether it was the provider or whether it was the software vendor, and kept them in the case. So just a very early example of how you could see how a judge might say, wait a minute, if this wasn't standard of care, it wasn't standard of care. What does it matter whether it's a flesh and blood doctor giving this information or whether it's AI?
Crazy times. So, looking ahead, are there any emerging trends or changes in legislation that we should be aware of regarding the informed consent process and how they might impact healthcare practices?
Well, I mean, I think so. The informed consent doctrine goes back over a century. So it's not one of those topics that necessarily changes overnight. I know I happen to be part of the Risk Management Society in Massachusetts when our Board of Medicine, like 10 years ago, decided to make its own rules about this. And everybody threw their arms up, basically saying, how could you do this? We've had this, this doctrine for over a century. Now you're making it more complicated. But I do think that's probably the most dramatic shift I've seen in the number of
Yeah.
years. But there are often tweaks in terms of how judges look at informed consent, and that gets embodied in case law and affects how we handle these things. Um, I do think that overall, the influence of technology, electronic health records, AI, into this space is probably the biggest moving part. I don't necessarily foresee that there will be legislation that specifically targets informed consent, but to the extent that you're using AI tools to do that, if, for instance, Congress tomorrow drops a set of legislation about, AI responsibility and AI safety and AI governance in healthcare, those tools might be swept under that umbrella, and it might raise a whole host of legal complications that we can't foresee at this point. So I would say pretty much everything about medical documentation and medical decision making, particularly when it comes to these emerging technologies, puts everything in flux. So it's something that we have to keep an eye on, even though the backbone legal doctrine goes back over a century. Sometimes it doesn't apply well when we break things with technology, right?
for the, just to add on, so like, do you see like the states being more active in legislation, like where Texas has the Texas Risk Panel, very specific, solving for a very, I'll call it linear, issue. Louisiana tried to kind of do the same. Do you think that it's a state more evolving, or is it more federally going to be mandated? How these things change over time?
Well, that's fascinating because I think we've been seeing a snippet of that and what relative to AI, because there seems to be some paralysis at the federal level because it's frankly exceedingly complicating, and trying to
Right.
legislate about something that you don't understand is dangerous and complicated. So, but we've seen states coming out with rules about AI and are
Yeah.
about, given that there doesn't seem to be a lot of coordinated movement at the federal level. So I'm curious. I don't know the answer to that question, but
Yeah.
I wouldn't be surprised if we see states, like California and New York really getting, as they did with data privacy, wanting to get ahead of, sort of the stagnation at the federal level on this issue, and trying to kind of like dictate the bar
Yeah.
about,
Sure.
as we've seen with some other issues.
Right. Okay, awesome. So before we kind of finalize ourselves here, let's talk about Solveig. Why don't you just give us some final thoughts, any best practices you would share with our audience today?
I think the one that I haven't mentioned is the importance of informed refusal. Um,
Okay.
Here's an example. A patient comes into the emergency room, has some chest pain. They check the person out. Okay, maybe some slight EKG changes, but nothing terrible. And they do serial troponins and recommend that the patient stay under observation until the troponins are back the next morning. And the patient adamantly refuses to stay in the hospital, wants to go home. So whether they have an informed refusal form is not the issue. Some facilities do, but it would be critical to document in that patient's record the discussion that the provider had about what might happen if they go home, that they might have a myocardial infarction, they might actually die, and the patient still refused and adamantly decided to go home. So I think informed refusal can be as important as informed consent in that regard.
You, Chad, any final thoughts or best practices you'd like to share?
Um, yeah, I mean, I think that the bottom line for best practice for me is that there is evidence of a robust discussion, not a robust form. That, I find it more defensible sometimes even when I have a generic form in front of me, but I have a doctor who's taken the time in the free text narrative of their note to say, we had a long discussion today about the risks, benefits, and alternatives of this procedure. And maybe they don't list everything that they discussed, but they talk about some highlights. Even putting that in your progress note, I think, can really help. But I do really love it when you have the practices or the hospitals that have the incredibly specific forms, because there is utility to that form if you break it down and you're actually including, the most prevalent risks or some of the alternatives. And then, if you have a patient signature, it does put some weight on the patient, for a legal matter, because they have to acknowledge, for instance, at a deposition, that's my signature. So I signed this. And then the question, which is never a good question for them either way, did you read it before you signed it? Right. And either way they answer that question, it puts some of the weight of that decision making on them. So yeah, I mean, I think a process in which you document you had a fulsome discussion, and to the extent that you can have more specific forms, the more legally defensible from my point of view.
I have one thing to add to that too.
Please.
I think it's really some of the best informed consent documentation I've seen included information about what questions the patient asked and how they were answered.
So that level of documentation where they're actually keeping almost like a
Almost.
track of the conversation, right? Yeah.
Yeah, it's the same kind of thing you document when you have an adverse outcome and you're doing disclosure. You want to make sure that you document fully what questions were and how they were answered.
Awesome. Let me ask you one question, Solveig, because I spent the weekend in the ER with my mom, my 84-year-old mother, so I have all these things going through my head, and it's interesting to me. So if a nurse goes over the procedure that's going to happen with the patient, and the doctor only just acknowledges and signs it, is that not accurate? Is that's not an informed consent in your mind?
It's not really an informed consent. I mean, it could be if the doctor follows that nurse's discussion, goes and talks to the patient and says, now I understand you talked to my nurse about what's going to happen, and then says, please let me know if you know, what are your questions about it?
Yeah.
And, it might be helpful for the doctor to say, use teach back at that point. So what did you understand about what the nurse told you about?
Okay.
Tell me what you understand about what you were just told. That might be a way to really validate that the patient really knows what's going to happen.
Okay. And then does the title or if it's a physician assistant, does that change where they are able to have an informed consent? Or no, it always has to be the
Well, it
physician
has to
that's
be
attending?
or the person providing the procedure. I saw that there was a question in the chat about nurses obtaining informed consent, which is specified in their scope of practice. That would be a nurse practitioner typically. And
Okay.
in some states, nurse practitioners can practice independently, such as in my state of Minnesota. There are nurse-only clinics in the state of Minnesota, and they do procedures. And if they are the person providing the procedure, then it's their responsibility to get consent if they do not have an agreement with a physician. I mean, if they are not supervised by a physician, they can get that consent for that particular procedure. That's not the case with PAs, by the way, because PAs still are not independent practitioners in any state that I'm aware of.
Okay. Good information. So good segue. Let's get into some of the Q&A that's out there. I see there's a second question from my man, Dr. Fink. He said, I think I hear that Solveig was from Minnesota. That is correct. My understanding is that the Mayo Clinic had or still has an institutional policy that the informed consent process does not require documentation. Is this true? And if so, Chad, is there any legal ramifications?
It's not true anymore.
Okay.
That happened in 2009. I'm very aware of it. And there was a lot of talk about the arrogant Mayo practitioner who assumed that they would always do things perfectly, so there was no need for informed consent. Happened in 2009 or 2008, but the State Department of Health and Medicare and Medicaid were actually called in, and they did change their practice at that point. So that's it's a story that perpetuates. I hear about it frequently when I travel. So what are they doing at Mayo? But yes, they do document their informed consent now.
Okay, awesome.
We do also have another question from Ann Human-Kearney. She asked, can you elaborate on the need for interpreters, sign, and language?
If you have a person who is either hearing impaired or does not speak English, it is imperative that you have a person who is not a relative interpret for them. And so that means having either an interpreter available via telephone to do interpretation or via
video conference or something.
Video conferencing, and or having a video conferencing sign language interpreter present. The reason I say not a family member is if you think about it, say you have a patient who's going to have a procedure, you have an elderly patient who's going to have a procedure, they have a son or daughter with them, they speak a foreign language, and the physician is explaining the risks of the surgery, and the child decides, oh, if they hear that, they won't have it. They won't have this surgery, and I don't want them to have it. I mean, I want them to have it, so I don't want
Yeah.
them to do this. So, that's the primary reason why you want to make sure it is a professional interpreter who does not have any bias as to whether the patient should sign the consent or not.
Interesting.
Mhm.
Yeah, and
Naomi,
just
and
to
go ahead,
bolster.
Chad. Yep.
Oh no, sorry, just to bolster that. I mean, I've seen cases which are exactly along this line where a son or a daughter, stepped in to interpret, and it's not it's not a legally defensible situation because the doctor is going to say, well, I said X, Y, and Z, and they're going to be aligned on their side. No, you didn't. I didn't ever said that to my mother.
Yeah.
So I agree, maybe for slightly different reasons for the legal defensibility viewpoint of everything Solveig just said.
Okay.
I also think it's great that we busted a Mayo Clinic myth. So now if I ever hear this again, I'm going to know this myth has been busted by Solveig. So thank you.
There you go. Yes, we're all better off knowing now that they actually do it. So, Leslie has a question. Leslie Butler, do you recommend that physicians sign the consent form?
I think they're supposed to under
Yes.
Yeah.
under the federal regulations. I think they have to.
Yes, under
Yeah.
CMS regulations, they have to sign it.
Yeah.
And it should not be signed, more than 30 days ahead of a procedure. I mean, if it's signed in the physician's office, it can be, but it has to be the physician's signature.
So in a time, do you have time constraints then, Solveig, or you've seen time constraints put in place where I meet a physician in his office or her office, and then when I go in for the procedure, 35 days later, would they re-consent?
It should.
How would that look? They should. Okay.
Yeah, I mean, if they're audited by CMS, CMS would say that's out of the realm of possibilities. Yeah.
Okay. Good to know.
That's the same for the pre-surgical physical. It has to be within 30 days of the procedure. But most consents are really obtained the day of the procedure. I mean, they're reinforced if they've been gotten ahead of time. They're reinforced the day of the procedure, ensuring that the patient hasn't changed their mind,
Right. Any other questions, Naomi, out there?
Someone asked a question. It's showing up as under my name, but I didn't post it, so I'm not sure who actually asked it. But it says, would you speak about best practices for informing the patient that their procedure is scheduled as overlapping in terms of CMS OIG recommendations?
I'm not sure what they mean by scheduled as overlapping.
I think they're talking about a concurrent surgery situation where you have an attending who's going in and out between several ORs. We had a big slew of cases in Massachusetts about that. And that's actually why the board, in part, changed the informed consent requirements, because they now have requirements about identifying who's in the procedure and if they're going to be leaving the procedure. And it was specifically about this concurrent surgeries.
Wow.
But so, I mean, all I can say is, if your state requires it, or if some other regulator starts requiring putting that information in, you best do that. In Massachusetts, you would have to do that. That would not be a legal informed consent. If you didn't include information that you're going to be leaving the procedure midway. So at least relative to the board regs. So it could come in. It could come into to view. I'm not so sure what the other states are doing about this, because it was a really specific slew of cases that we dealt with that were reported in the news. So Yeah, but I wouldn't be surprised if other states started to follow suit or other regulators in requiring that information.
So Chad, I would assume that if you had an adverse outcome in surgery and it's in the electronic medical record, the circulating nurse documents when people are in and out of the room. And it's very clear the medical record when the surgeon is in the room and when the surgeon is not. And if you had an adverse event occur and it's obvious that the surgeon wasn't even in the room, that would make it much more difficult to defend a case, correct?
Obviously it would raise challenges about, what was the level of attention and,
Exactly.
yeah.
Looks like that's all the questions we have.
Awesome. Well, I just want to thank Chad and Solveig for your time today. Hope it was informative to our guests. Thank you all for attending. We really appreciate it. And again, please come see us at HIMSS and come see Chad at our breakfast briefing on Tuesday at HIMSS. So thank you again for your time, everybody. And stay tuned for the next one coming up in a couple months. Have a good afternoon.
Thank you.